The system was designed for order, not for justice. In the stark light of the 18th century, the statutes of England were not written in ink, but in blood. This was the era of the Bloody Code, a labyrinthine legal framework where the shadow of the gallows fell upon hundreds of transgressions, each codified with dispassionate precision. The law did not distinguish between desperation and depravity. It only categorized the act and prescribed the penalty. By the turn of the century, the number of capital offenses had swelled from a mere 52 over 200. This proliferation of death sentences was not a response to an unprecedented wave of criminality, but a calculated legislative expansion. The state, in its wisdom, had determined that the most effective deterrent was the final one. The catalog of crimes deemed worthy of extinction was vast and disturbingly varied. Murder, treason, and piracy, the traditional pillars of capital punishment, were joined by a host of new offenses, reflecting the anxieties of a propertied class. To damage a fish pond was to risk one's life. To appear in disguise on a public road was to court the hangman's noose. The act of cutting down a young tree, an act of simple vandalism or agricultural sabotage, was elevated to the same legal standing as the taking of a human life. The law extended its reach into the very fabric of urban and rural existence. Impersonating a Chelsea pensioner, wrecking a ship, or even damaging Westminster Bridge were all activities that could lead a man or a woman to the scaffold. Each new statute added another thread to the web, ensnaring more of the populace in a system where the value of property was frequently equated with the value of a life. The list grew with a relentless, bureaucratic logic, each addition a testament to the legislature's belief in the ultimate sanction. The law was an instrument of immense and terrifying power, and its application was as methodical as it was merciless. It was a cold arithmetic of transgression and retribution, where the sum was always death. The chasm between the severity of the crime and the finality of the punishment was starkest in cases of theft. In an age of burgeoning commerce and stark social inequality, the protection of property was paramount. Consequently, the law prescribed death for acts of petty larceny that, by modern standards, would warrant little more than a minor penalty. Stealing goods valued at more than 5 shillings from a shop, the equivalent of a few days' wages for a laborer, was a capital offense. To pilfer a handkerchief from a pocket, if proven to be worth more than a shilling, could condemn the thief to the same fate as a murderer. The courts processed these cases with a chilling and routine efficiency. Evidence was presented, testimony was heard, and verdicts were rendered, often in a matter of minutes. A moment of desperation, the theft of a loaf of bread or a length of cloth, could initiate a legal process that ended inexorably at the gallows. For many, it was a choice between starvation and the noose. A servant who stole from their master, a hungry child who snatched a pie, a worker who pocketed tulzo fell under the wide and unforgiving net of the code. The system did not concern itself with mitigating circumstances or the desperation that drove the act. It saw only the violation of property rights. The public spectacle of execution served as a brutal lesson for those who might be tempted to transgress. Men, women, and even children were hanged for stealing livestock, poaching rabbits from a lord's estate, or shoplifting a length of ribbon. The sheer volume of these cases demonstrates a legal system less interested in proportionality than in making an example. The life of the poor was deemed a disposable commodity, readily sacrificed to secure the possessions of the wealthy. The courtroom was not a forum for mercy. It was a procedural gateway to the gallows, where the theft of a sheep was weighed on the same scales as the most heinous of crimes, and found equally wanting. The judicial machinery ground on processing lives with the same detached logic it applied to property disputes. At its core, the Bloody Code was not merely a system of laws. It was a sophisticated instrument of social control, wielded by the ruling elite to maintain a rigid and unforgiving hierarchy. The primary function of this legal terror was not to dispense justice, but to instill a pervasive and paralyzing fear. The law was a ghost that haunted every parish, a constant and visible reminder of the state's absolute power over life and death. The public nature of punishment was integral to this strategy. Executions were not hidden away behind prison walls, but performed in the open, at Tyburn or on local gibbets. As grand and gruesome civic spectacles, crowds would gather to witness the final moments of the condemned. their deaths serving as a visceral sermon on the consequences of disobedience. This theater of death was designed to imprint upon the collective consciousness the futility of challenging the established order. The fear was systemic. It was woven into the fabric of daily life, communicated through broadsides detailing the crimes of the condemned and whispered in stories of the hangman's procession. It was the fear of the arbitrary power of a magistrate, the fear of a neighbor's accusation, the fear that a single misstep could lead to an irreversible and public end. This was control through intimidation, a psychological warfare waged by the state against its own people, particularly the poor and disenfranchised. The law, in its majestic and terrible pronouncements, was a constant assertion that the social order was immutable, and that the price for challenging it was annihilation. The gallows did not just break the necks of the condemned. They were intended to break the spirit of an entire class. It was a declaration that the lives of the many were subordinate to the property of the few, a principle enforced not by consent, but by the ever-present threat of the rope. The system was not broken. It was operating exactly as intended.